I'm involved in a trust and the trustee is just not doing their job. Hi, I'm Darren Findling of the Probate Pro, and my law office handles trust disputes, fights involving a trust. The Probate Pro litigates trust disputes in the probate court. What do we mean by a trust dispute? Well, as the name implies, it involves a trust. That trust vehicle could be a revocable living trust, an irrevocable trust, a supplemental or special needs trust, any trust vehicle in which there's a dispute. It may involve the activity of the person who created the trust or the trustee in how they're handling matters. And it also may involve the trust beneficiaries. It may also involve how the trust is interpreted. For example, language within the trust that's unclear, and depending on how that language is interpreted, could mean the difference between how various people are treated. One of the most common forms of trust litigation involves when somebody that has a trust dies and a new trustee takes over. For some reason, those people often believe that they are not held accountable to the trust beneficiaries and they can simply do as they please. They fail to follow the statutes, they fail to inform the trust beneficiaries, and they simply keep everyone in the dark. This is a large driver of litigation. As a trust beneficiary, you are responsible for all sorts of requirements that may not be intuitive. Responsibilities relating to notice and accounting and communication. This type of duty of care that's required triggers a lot of litigation. Most probate and trust litigation occurs within the probate court itself, which has jurisdiction over trust disputes. But that doesn't mean it's the only place a trust dispute can occur. It can also occur in other courts. Let's dig into the timeline to understand how a trust matter is handled in the court system. Here is a typical timeline from the beginning to the end. As you can see, there are no dates associated with this timeline because depending on the particular issue, the dates may change. Some probate matters, probate litigation, are resolved in one hearing, and others go on for many months. The dispute begins by the filing of a petition or a complaint in the probate court. It is this petition or complaint that sets forth the allegations upon which you're seeking the court's involvement to resolve. It may include a jury demand, depending on the circumstances. But it is this complaint or petition that starts this entire timeline. Then, after the petition is filed with the probate court and the requisite filing fee has been paid, it is the obligation of the petitioner to serve the interested parties. It could be defendants or simply trust beneficiaries, or maybe the interested party includes the trustee. There's a court rule that specifically guides you on how to serve the defendants or interested parties when there is a trust dispute. Carefully read over that court rule to understand your obligation, because it's quite frustrating when you attend the hearing only to learn that it's going to be adjourned, delayed, because you failed to give appropriate notice. It is this notice that allows the defendants or the other interested parties to participate in the litigation, to understand what is being alleged so they can decide whether they want to participate, agree, object, etc. Once that lawsuit has been served among the interested parties, there is an opportunity for those interested parties, as we stated, to respond. We call this a responsive pleading. It may be in the form of an answer or a response, depending on the particular petition or complaint that's filed. Again, carefully read the court rule or statute to dictate how you are required to appropriately respond. Failing to answer the claims correctly can subject the answer to an admission. So it's really critical that this particular aspect of the timeline is done correctly. In addition, there are rules relating to the assertion of what we call affirmative defenses. So if you fail to properly plead the answer, it can have ripple effect and ultimately final effect on your claim, and it can truly impact your defense of the original claims. So it's critical, again, that you use counsel of an attorney and following all the requisite rules before you file the responsive pleading to the original petition or complaint. When there is litigation involving a trust, the court rules provide for discovery. Discovery is a critical part of the litigation timeline. It allows all of the interested parties that are involved in the trust matter to learn additional information or sufficient information for them to litigate the claims and to prepare for trial. So, for example, depositions, requests for admissions, interrogatories, subpoenas. This all occurs within the discovery phase. Sometimes discovery is quite short, and sometimes it goes on for many months and is quite extensive. That typically depends on the complexity of the litigation. Generally at the conclusion of discovery, but often well before, the court may order the parties into alternative dispute resolution, or ADR. ADR can look like many different forms of resolving the dispute short of trial. It could include case evaluation, which is a process in which uninterested attorneys evaluate the file. It could include mediation, or a facilitative process to try to bring the parties together. The ADR process sometimes is a one-time event, and sometimes it goes on for quite a bit of time. ADR is really an effective way of resolving disputes short of a jury trial or a multi-day hearing in which you're really at the whim of the court system and the judge's schedule. It often is a way to allow the parties, after this extensive litigation, to simmer down a little bit and start recognizing that this is very expensive to litigate a trust matter, and it may be time to try to bridge the differences and to create a settlement. Shown on this timeline as a step following ADR is really not a great representation of what I'm referring to as motions. There are motions or petitions or requests of the court that occur throughout the litigation timeline. But in this particular context, what I'm trying to highlight is that often there are motions for summary disposition. This is really a request of the court that, based on, and now that discovery is closed, and based on all the facts that are before the court, there's really nothing here. Or, conversely, that there is sufficient information to make a ruling short of a trial. Now, the motions relating to summary disposition are based on a particular court rule, and they can be quite complex, and the drafting of these motions can be quite involved. Working with a skilled litigator can help best position these motions to hopefully avoid the need for a trial. All along during this entire litigation timeline, eyes are on the final event, which is the trial or the evidentiary hearing. Everything that is being done from the beginning all the way through to the end is in preparation for this event. As I stated at the beginning, this could be a jury trial. It could be a trial in front of the judge. It could be a short evidentiary hearing where there's a focus on one particular issue, and it could be an involved trial. It could be a matter that's resolved in an hour, and it could be a multi-day or weeks on end trial. It depends, of course, on the complexity of the matter that's at stake. So there it is, a typical trust litigation timeline. Please understand that this litigation timeline is just for illustration purposes. It shouldn't be relied on because there's no dates here, there's no statutes here or court rules. It's to give you a general understanding of how trust matters proceed through the court system. Now, as a practicing trust litigator for 25 years, I can tell you that every trust file operates differently. And even though this is a general concept, Each trust matter I've been involved in has its own way of proceeding through the system and its own narrative. The most important piece of advice I can give to you is to hire a skilled, competent trust litigator. A trust litigator that understands how to read a trust, interpret it, apply it to the law, be able to orally advocate and litigate the matter at the court system, and a lawyer that you can trust with your important matters. If you're involved in trust litigation and you want to speak to a lawyer, or if you've got questions about a trust, give us a call at the Probate Pro. You can reach us at the number 833-PROBATE, or of course visit us through our website, theprobatepro.com. We're happy to have a discussion with you about your matter, and I wish you all well.